When justice is denied not by verdict, but by silence, what recourse remains for the accused? I did not ask for sympathy. I asked for support, and they gave me bureaucracy. In a system where Section 174 offers a lifeline to the wrongly accused, why does the Legal Aid Board hesitate to fund the fight? Mnisi's lament isn't just personal, it's political. It's a cry from the margins, echoing through the corridors of power. Today on Skybridge, we dissect the silence, the loopholes, and the cost of justice. Mnisi's story is more than a lament. It's a reckoning, and it's time we listen.
My apologies, my lord, I did not get the question. There's a bit
Yeah,
of a
what
noise
type
that
of
is coming.
consultation is it? Because I thought on Friday, when you adjourned last week,
Yes, my lord.
the question was you were going to ask the Legal Aid Board
Yes, okay, on that one, my lord.
to
Yes.
authorize you
Yes,
to proceed with the application or
yes,
not.
my lord. Yes, my lord.
So that's what we must do.
Oh, thank you, my lord.
So what is the picture now?
There were submissions, my lord, that were made on behalf of that are made on behalf of Mr. Mncube
Yeah.
and on behalf of Mr. Sibiya with regard to their wish that I should bring an application in terms of Section 174 on their behalf. And there were some requirements or some information that I was supposed to furnish to the legal aid for them to make an informed decision on whether or not they would be amenable to allow me as a creature of a statute, as a creature of instructions to proceed with this application in terms of Section 174. That information was furnished. The response was that despite the fact that that information was furnished, they are of the view that they are not in a position, because central to the issue of this Section 174, it was the issue of finance. Because the information that I submitted to them is that I am representing two accused persons, and the state's case has run for almost 3 years. It will be a travesty of justice for me to stand up here and bring to the court something that will not be meaningful to the court, because I'm always mindful of the fact that whatever that I'm bringing to the court should be something that is giving the court some sleepless nights. And that is what I intended to do, my lord. So, and again, it would not be in the interest of justice on behalf of the accused person if I was just to stand up here and bring an application just to go through the emotions. That's not in my nature. So I requested them to allow me the time to prepare, which I specifically stated the period. But in terms of their calculations, in terms of the money that they would have to finance this application with, then they are of the view that they would rather not agree to the request. And I must hasten to mention that that request is basically not mine. It's a request that actually came from the two gentlemen that I'm representing here. But legal aid then says, no, Mr. Mnisi, if you want to proceed with the 174 application, we don't bar you, we don't stop you from proceeding, but know that in terms of us financing it, we'll have some reservations, which is then the communication between legal aid and us then stopped there up until today. Today, they availed themselves to court. On the adjournment, I communicated that position to the client, to Mr. Mncube and Mr. Sibiya, who still are of the opinion that it will be in the best interest of administration of justice from their point of view that we bring this Section 174, and then thereafter they started to ask certain questions that I was not in a position to respond to. And then I requested legal aid to go and attend to those questions or to answer those questions as are questions that should really be answered by legal aid. So there were still some deliberations around the questions that they had been asking legal aid. Then there was a moment when we were requested to come and see the court in chambers with a team from the state attorney. So we had not yet finalized those discussions. But I stated to them very clear that it will be it will be a challenge on my part to go and sit for 4 weeks in preparation of the Section 174 without any reimbursement. And I'm repeating that it's going to be a very serious challenge, Manuel.
Without what?
Without reimbursement. In other words, I'd need to go and sit in my chambers for 4 weeks preparing for this 174 because it's going to be a very detailed 174. And at the end of it, will just be seated there, fully concentrating on this application, not be involved in other work. I don't think I'll be in a position to do that, my lord. I've already done that since January. I've read almost like 40,000 pages, and I don't want to get there. But I don't think I'll be in a position to do that for the second time again, my lord. Thank you. That is the
But
position.
what are your instructions from your clients?
My instructions from the client are that, my lord, they would still wish us to bring the Section 174. But the challenge is who's going to finance it. Thank you, my lord.
Yeah, okay. But you're prepared to fund an application for 174?
Well, it's the appearances,
Yes.
and in terms of the tariff, they obviously are entitled to fees in terms of the tariff. They have, in terms of the tariff, they've got 2 days, 2 hours preparation per day, plus obviously the court appearance. But in addition to that, legal aid's not prepared to give the additional amount.
Why would you say you have to prepare, and I'm not saying you can't, you have to prepare for 4 weeks, you say it's 4 weeks.
That was just my estimation, my lord. I've taken into account the issues that I need to deal with. I've taken into account the volume of work that I need to go through in preparation for this application, and I've taken into account the number of accused that I'm representing, my lord. And I'm also taking into account the nature of the evidence that was led against accused number 1 and against number 2 up to this stage of the trial.
But you've heard the legal aid board saying the most they can provide is for 4 hours, apparently.
My lord, in the response by the legal aid, they are mentioning that, but they are saying there's a 2-hour preparation that they would pay when the court is sitting, which is a trial date. In other words, for instance, today, they will be prepared to pay that 2 hours, which is meant for the preparation in view of the matter that will be proceeding. But now this is different because this preparation will be done when the court is not sitting. So now I requested some clarification from them as to what do they mean by that. I'm unable to get a precise answer on whether or not they are saying it is fine, you can go and prepare, but we will pay you for your preparations per day only for 2 hours, irrespective of whether you're preparing for 7 hours per day, and up to a certain maximum number of days. I don't know what it is that they are actually saying, my lord. I wrote and requested the clarification from them, but I still cannot get what is it that they are saying. Thank you, my lord.
Come and explain again, ma'am. What you... yeah, no.
Sorry, my lord. Yes, what the committee said is that they are only allowed to charge the tariff fee, and they're not going to get paid to prepare for 4 weeks at home. So they're not going to, and effectively that's what they said, and even in the clarity, that's what they said. And they did ask me before court, and that's what I explained, that they will get the tariff, which is 2 hours in trial pre-trial preparation plus the trial. And they also get increased fees per trial date. So they don't get the tariff; they've got special fees for the trial day. And the committee was of the opinion that that's sufficient.
Okay, thanks. Mr. Mnisi, so you say you need 4 weeks to prepare.
I said, my lord, that was just an estimate.
So how long do you think you need, according to you?
I think the court will remember that as early as January, in February, I said to the court, I would have completed reading the record on a specific date. Came that date, I had to come before court again and make a request for a further postponement, and I was lambasted, my lord. So I don't want to go through that experience again in preparation for this. But still, without clear terms in regard to payment, my lord, I would not be preparing. I will not be preparing anything, because it doesn't really come out clear. But from what I understand from Legal Aid South Africa is that for this section 174, their decision is they are not prepared to reimburse a person that is going to prepare to bring this application on behalf of the accused.
But I thought you had read the record again.
Yes.
You were in court when this matter commenced.
Yes.
Then after that you were granted 4 weeks, 4 months. 4 months and 3 weeks.
And that was after I was lambasted, yes, ma'am.
Yeah, reading.
Yes.
So you still want to read the same record which you have read and you have listened to in court?
It's different now, my lord. It's different.
What is different?
It's different because I'll have to bring an application in terms of 174.
Yeah, so what's the problem?
Then I'll have to revisit the record, my lord, and identify those points that I would want to include in my 174.
So you don't want to represent your clients, in other words?
Excuse me, my lord.
You are saying you are no longer wanting to represent your clients unless and until the Legal Aid Board says they will pay you for 4 weeks, whatever.
No, I never said that, my lord.
What are you
That is
saying?
the problem. That is the problem. I think I am being misinterpreted here. You see. And that has always been the perception that has been in the mind of Legal Aid South Africa, that I am after money. I am not after money, my lord. I was only requesting for assistance, but they are saying they are not in a position to assist. And that request does not come from me. It comes from accused. And if the court says, therefore, I'm saying I'm no longer representing accused, well, that does not come from me. But if that is what the court have in mind, then we can take it from there, and then from there, then we'll have to find a middle ground. And I do not want, my lord, and I'm requesting with due respect that this trial should not be about me. I should not be the centerpiece of this trial. I have been requested to come and assist these accused here, and I think up to thus far, I've done the best that I can. But for the focus of this trial to change from this accused person to be on me, I think that is very unfair. But if there's a perception that has been created that I am therefore saying that I no longer intend to represent this accused person, then let those who are entertaining that perception have it and tell me straight that I am no longer fit to represent these accused persons. Thank you, my lord.
So what are your client's instructions, in any case, about the application?
My Lord, I've said it many a times,
Yeah, I just want to hear it again. What
that
is-
they are saying, they are requesting that you should bring this 174 application. Well, my Lord, if I come here and present a document that is not up to standard, I would request that I should not be denigrated because of lack of proper preparation.
So 7 days is enough.
I am saying, my lords, in an event that I come here and present a document that is not up to standard because of lack of preparation, then that should not then come and haunt me and say, I have misrepresented the interest of these accused persons because of a shoddy work that I would have presented. Because 1 week for me in terms of preparation will not do, my lord. My lord, I think the court in the level of generality will understand that I'm a creature of instructions. I must take instructions from legal aid directly, basically to a lesser extent from my client, from accused number 1 and accused number 3, insofar as this case is concerned. But insofar as issues such as these ones, it is legal aid who must instruct me what to do. If the clients are saying we want this, it is legal aid that must talk to the clients and say, no, but that's not possible, or that is possible because of this and this and this and this and this. It is not me to come and stand here to try and convince legal aid that this is possible, because I am only a creature of instructions. If legal aid says to me, Mnisi, do it, I will do it. If legal aid says, Mr. Mnisi, don't do it, I won't do it. It's like I'm a pawn. I'm a pawn. I'm a horse. I'm sent here. I mustn't ask why. I'm sent there. I mustn't ask why. But I'm not saying I must do those. Like I must do things blindly. There are certain things that I need to clarify. But insofar as this process is concerned, I think it's a discussion that must take place between legal aid and the client. And after having finalized whatever that they would have discussed, then legal aid comes to me and say, Mr. Mnisi, these are the instructions that you are taking from us. But over and above that, legal aid is not only an attorney, it's also a funder of this whole process. So it's not fair for me to try and appear as if I'm fighting this battle on behalf of Mr. Ncube and Mr. Sibiya. There are no battles that are supposed to be fought here, my lord. It's a question of procedure and systems. I should actually be standing there and folding my arms and waiting for legal aid to come and say to me, Mr. Mnisi, these are your instructions that you're giving me. But it has not happened here. Actually, I should be saving myself from this agony of trying to analyze and convince that this should happen, that should not be happening. I must only be on the part of arguing legal matters here, not these administrative things, my lord. I'm not an administrator, I'm a legal person. That's my duty here at court, but it does not seem to be like that in this instance.
Sorry.
So I would request, my lord, that a further discussion that is going to involve accused number 1 and accused number 3, I should not be part thereof. I'm going to fold my arms and stand there and wait for specific instructions from legal aid, who are my instructing attorney. Thank you, my lord.
But did they pay you for preparation, for reading the record the last time? 4 months and 3 weeks.
I would rather not get there, my lord, because that's also a very sad story. But I would rather not get there. Thank you.
Mnisi's story isn't just heartbreaking. It's a warning. If Section 174 is meant to protect the innocent, why is it out of reach for those without funding? What do you think? Should legal aid be mandatory for all Section 174 cases? Have you or someone you know faced a similar legal struggle? Drop your thoughts below. Subscribe for more investigations that demand accountability. Thanks for watching. Bye.